It's an honor to welcome you all in this symposium of law and legal studies organized by Bhupal Nobles University Faculty of Law and in the supervision of Dr. Ashutosh Pitiliya, Dean of Faculty of Law. I'm very much pleased to invite all of you on board and to be with us in furthering the discourse upon the theme that we have selected for this symposium. And the theme is the changing liability or the changing concept of liability and its variables in the form and elements and in salient features that has been currently in different norm and in different paradigm shift being used and counter used in by way of legislation or through economics, etc. Now, our today's speakers, I would also inform you about today's speakers is Dr. Praful Bala Honta. She is basically a medical professional. I welcome you, Praful. I'm so happy that you have accepted my invitation without talking to me, without even contacting me, and through, you have been so polite with your gesture and reciprocal. So I'm really heartily delightful to welcome you on behalf of the host university and on behalf of the co-host, because the co-host is also here to extend the invitations. And coincidentally, it's a Sunday and I'm so short of time that I could not send you email on behalf of my co-host also. So very nice of you. We welcome you. Support. Yeah. And then I'll introduce Praful Bala Honta. She is consultant gynecologist, medical officer at Shree Haridev Joshi Government Hospital at Dungapur, and there is a medical college also. And she would be speaking on duties of medical practitioners in medical colleges. Our other speaker, of course, may be arriving very late, perhaps because he has sent us a message on phone just now, and he is Judicial Officer, Mr. Shiv Singh Chauhan, and he has been very much close associate of our host university, Bhupal Nobles, and been contributing a lot since long time. And his talk actually was on the concept of liability in family law. And there is a young speaker also, an alumni of Bhupal Nobles College, Faculty of Law. She is Miss Kripa Jain. She is pursuing Masters in Business Law through MLSU and had been on internships at various renowned legal partners. For example, Singhania, LLP, Gurgaon. Then she also contributed her papers. Yes, and she also attended some summer course from Harvard University, where she also got the credit to uh, be a part of the contract laws from trust to promise to contract. And to her credit, the best thing is that she had been awarded for her drafting as a second runners-up in moot court competition held nationally. Um, Today, we will be starting with our host university's talk on the theme, and he is the Dean, Dr. Ashutosh Pitiliya. Uh, I would welcome him and request him to take the platform to continue with his discourse. Dr. Ashutosh.
Yes, ma'am. Hello.
Yes, sir, we can hear you.
Respected Jayshree madam, Kiran madam, and Prafulata madam, and all delegates. Good evening to all of you. Today, my topic is liability under Motor Vehicle Act 1988. So, due to industrialization and urbanization, with cities turning into metropolitans and commercial powerhouses, the growth of automobile sector has also been increased over time. It has now become a common that every urban household has at least one car which they use as their family car. Being such a huge market, there are a lot of problems which these cities possesses to public as well as environmental in general. Rules were necessary to ensure the safety of drivers on the public road as well as that of the vehicle to ensure that the environment is not getting polluted due to their engines and other dangerous gases emitted by them. The Indian courts have attempted to clarify the concept of no-fault liability to provide justice to victims and determine the liability of insurer. Section 140 of the Motor Vehicle Act 1988 deals with the principle of no-fault liability. According to this principle, owner of motor vehicle are liable to pay for compensation of victim of accident caused by them. The criteria through which a person can claim no fault liability is where the death or permanent disablement of person arises due to use of a motor vehicle. The fixed amount to be paid in case of death 2 lakh rupees and in the case of permanent disablement a sum of rupees 50,000. Today, I would like to discuss various important cases of the Motor Vehicle Act regarding no fault liability and liability under third party insurance. The basic feature of principle of no fault liability is the claimant is not required to establish that the death or permanent disablement was due to any wrongful act of the owner. A person who is charged under Section 140 of the Motor Vehicle Act is also liable to pay compensation under any other law. The amount paid under Section 140 of the Motor Vehicle Act will also be reduced from compensation granted under Section 163A if such situation arises. The main purpose of Section 140 is to provide aid in case of emergency, and as such the claims under this section are to be disposed of one even a claim is made under section 163 and the individual is later required to pay differences in amount. In case of Oriental Insurance Company Limited versus Hansraj Bhai, the question was arises with regard to whether a claim for compensation under section 163A on structured formula basis would be in addition to or an alternative measure to claim for compensation under section 140 of the Motor Vehicle Act. The court held that the compensation granted under section 163 is a final measure and not an interim relief, and as such the adjustment of compensation paid under section 140 is awarded under no fault liability principle that is payable under 168 of Motor Vehicle Act, not under section 163A. In National Insurance Company versus Sinitha, the question posed to the court was with respect to whether the claim under section 163A of the Motor Vehicle Act falls under principle of no fault liability or fault liability. The rationale that helped the court arrive at its decision in this case was the fact that since since it was open to the concerned party to, to defeat any claim under section 163A on the ground of wrongful act, unlike a claim under section 140. Although section 140 clause 3 is similar to provision of, under 163A, which states that the aggrieved party need not establish the wrongful act of opposite party. This gives the opposite party a chance to defeat the claim. From this rationale, the burden of proof rests on the defense, and as such, it is founded on the fault principle. Further, titles of both sections themselves clarify states their intention, that is no fault, as compared to third party risk. The court held that although the structured formula basis was shortcut to provide quick remedy in case lead to substantial claim and thus cannot be banned from any defense as as in the no fault principle. The insurance against third party
Sir,
Risk,
excuse me, sir.
yes,
Excuse me, sir.
yes, madam.
Do you have any PowerPoint? Any
No, madam.
PowerPoint? Okay, okay.
No, madam.
Sorry,
Okay,
sorry, sir. Didn't.
okay, okay. The insurance against third-party risk refers to the safety granted to third party who are any individual other than the insurer and the holder of insurance policy. The third party has been given an exclusive definition to cover all possible individuals, including the government. The responsibility of payment rests on the insurer, who are responsible to cover all liability that may arise in case of death or bodily injury caused to any person, property, or third party against arising out of use of motor vehicle covered by insurance policy in public place. It also includes the liability in case of death or bodily injury to any passenger of public service vehicle, damage of third party property, and death bodily injury to of third party. In case of United Insurance Company versus Karamchand, the court established the principle that the parties include all those who suffer as result of the use of said motor vehicle in public places. The parties could be occupant of the vehicle or even any other person traveling by road or in other vehicle who fell victim to the accident. All these individuals are liable to be awarded compensation as a result of such an accident. The compensation is to be awarded by insurance company that the concerned vehicle hold a policy with. In Tulsi Sahukar versus New India Insurance Company, issues addressed by the court was with regard to the third party liability after the death of insured and during the process of transfer of ownership of vehicle. The court held that the transfer of the insurance policy to the wife of deceased was automatic and was deemed to have happened even the policy had not changed the name of the beneficiary, despite the transfer of ownership of the vehicle has already occurred. Thus, the liability of the insurer would still be valid and does not cease to be effect even if the owner fails to intimate the insurer about the uh, as per the provision of the act. The insurer would thus still be liable to compensate third party victim who his policy owner has harmed. In another case, the divisional manager Oriental Insurance Company versus Tushar Rajan Das. The issue that the court addressed was with regard to the situation that arise in the event of cancellation of insurance policy prior to an accident. According to the fact of this case, the insurance company themselves cancelled the insurance policy prior to an accident due to dishonor of check despite toward the premium of insurance policy. The question that arose was whether the legal heirs of deceased victim uh, third party could still claim compensation from the insurance company. The court held that since the contract of insurance contemplates third party who are not signatory of the party, this essence need to be mentioned and thus regardless of check being dishonored or not, they are protected by such insurance contract. The dishonor of the check does not absolve the insurance company of their responsibility. However, after compensating the third party in this case, the company can require to insure to repay the same amount to the company. This is called pay and recover principle. The doctrine of pay and recover principle covered under section 149 of Motor Vehicle Act. The basis essence of this policy is that the insurer is required to dispose of the claims for third party compensation and quickly as possible as they are most in need of financial aid at the time of accident or in emergency. This does not absolve the holder of policy completely from paying any amount to the insurer for indemnifying them. In case of some is substantial and the owner does not have such a large amount to pay the amount at the moment of it. The insurance company can pay on behalf of him and recover the same amount after some time. In National Insurance Company versus Swaran Singh, the question dealt with was what defenses could be used by insurance company to prove that they are not liable to pay any sum of money according to doctrine of pay and recover. The court held that only if the defense used by insurer has formed a fundamental part of the accident that can insurer escape from their liability. The defenses available to insurance company are as follow. First, if the owner of the insured vehicle or driver of the same was carrying fake license. Second, if the owner of insured vehicle or driver of the same carried no license whatsoever. Third, if the owner of the insured vehicle or driver of the same carried a expired license and no application had been made for renewal of the same. Fourth, if the license held by the driver or owner of vehicle carried another class of vehicle which was not that which caused the accident. And last, if a person holding learner's license was solely driving the vehicle. Thus, the burden of proof is rests on the insurance company to prove the validity of defense. The insurance company shall also prove that the insured was guilty of negligence and failed to exercise reasonable care of fulfilling the policy criteria. The rule put forward by the court in determining the verdict of this case and for further cases resembling the same was rule meant for this purpose. The Motor Vehicle Amendment Act 2019 also provide the establishment of National Road Safety Board under the central government as well as National Transport Policy and National Register for Driving License and Vehicle Registration. These amendment acts also provide for means of obtain driving license online and better insurance policy. In order to provide more stringent measures and and increased penalty, which is the need of hour, in order to control issues such as road and environmental health, road safety, the fitness of vehicle, and provide additional means of compensation for victim of the road accidents. So, thank you, madam. This is my presentation.
Right, sir. Uh, so now I invite our next speaker, Dr. Praful. Dr. Praful, are you here? Dr. Praful,
Yes, yes, ma'am. Hello, am
please,
I audible?
please turn on your camera, ma'am.
Yes, yes. Is it
Dr.
okay?
Ashutosh, today you have to chair the session, so please stay till the end because our co-host has asked me at what time he has to turn up. I have requested him to be here by 7:45 or after. But Praful, you have to take full 1 hour if you can to absolutely clarify all the knowledge with regard to liability in medical profession as much as possible. So I invite on board our next speaker, Dr. Praful Bala Honta from Dungapur Medical College, Rajasthan.
Thank you so much to all respected on-board members. I'm Dr. Praful, consultant gynecologist, medical officer in Dungarpur Government Hospital, and I feel deeply honored to discuss the topic duties and responsibilities of a medical practitioner in general. I'm going to
Wait,
discuss.
yes, Ashutosh sir, you want to say something?
No, no, sorry, madam.
All right.
Okay.
Yes, ma'am, continue.
Okay, so I'm going to discuss today about the laws and ethics for a medical profession, I will be able to do as much I know and doing in routine. If something is wrong or remains incomplete, I hope that all the respected members will do it correct and complete. So, in continuation, duties and responsibilities of a medical practitioner in general. First of all, a character of medical profession. A doctor with the qualification of MBBS with post-graduation degree, diploma, or with equivalent qualification in medical field. A physician shall uphold the dignity and honor of his profession. The prime object of the medical profession is to render service to humanity. Reward or financial gain is a subordinate consideration. No person other than a doctor having qualification recognized by Medical Council of India and registered with Medical Council of India or State Medical Council is allowed to practice modern system of medicine or surgery. A person obtaining qualification in any other system of medicine is not allowed to practice modern system of medicine in any form. Maintaining good medical practice, the principal objective of the medical profession is to render service to humanity with a full respect for the dignity of profession. Physicians should merit the confidence of patients entrusted to their care, rendering to each a full measure of service and devotion. Physicians should try continuously to improve medical knowledge and skill and should make available to their patient and colleagues the benefits of their professional alignments. The physician should practice methods of healing founded on scientific basis and should not associate professionally with anyone who violates the principle. The honored ideal of the medical profession imply that the responsibilities of the physician extend not only the individuals but also to society. Membership in medical society for the advancement of profession. A physician should affiliate the association and society of allopathic medical professions and involve actively in functioning the such bodies. Maintenance of medical records. Every physician shall maintain the medical records pertaining to his or her indoor patients for a period of 3 years from the date of commencement of treatment in a standard performa laid down by Medical Council of India. And if any request is made for medical records either by patient, authorized attendant, or legal authorities involved, the same may be duly acknowledged. The document shall be issued within period of 72 hours. A registered medical practitioner shall maintain a register of medical certificates giving full details of certificates issued. When issuing a medical certificate, he or she shall always enter the identification marks of the patient and keep a copy of certificate. He and she shall not omit to record the signature or thumb mark, address, and at least one identification mark of the patient on the medical certificates. Every physician shall display the registration number accorded to him by the State Medical Council or Medical Council of India in his clinic and in all his prescription certificates, money receipts giving to the patient. Physicians shall display as suffix to their name only recognized medical degrees or such certificates, diploma, and membership honors which confer professional knowledge or recognized any exemplary qualification or achievement. Every physician should, as far as possible, prescribe drugs with generic names, and she shall ensure that there is a rational prescription and use of drugs. Every physician should aid in safeguarding the profession against admission to it of those who are deficient in moral characters or educations. Physicians shall not employ in connection with his professional practice any attendant who is neither registered nor enlisted under the Medical Acts in force and shall not permit such a person to attend, treat, or perform operations upon patients wherever professional discretion or skills is required. A physician should expose without fear or favor incompetent or corrupted, dishonest, or unethical conduct on the part of members of the profession. A physician engaged in the practice of medicine shall give priority to the interests of patient. The personal financial interest of the physician should not conflict with the medical interest of patient. A physician should announce his fee before rendering service and not after the operation or treatment is underway.
Ma'am Praful, we can't see you.
Uh,
Your camera is turned off, I think.
my side, it's okay.
No, but your camera should turn on while you speak. Is it off?
From my side, actually, I don't know what is going technically.
Madam,
Alright.
visible. You are very much visible, madam.
Okay.
Thank you. So, duties of physician to the patients. Though a physician is not bound to treat each and every person asking his services, he should not only be ever ready to respond to the calls of the sick and the injured, but should be mindful of the high character of his mission and responsibilities his charges in the course of his professional duties. In his treatment, he should never forget that the health and the lives of those entrusted to his care depend on his skill and attention. A physician should endeavor to add to the comfort of the sick by making his visit at the hour indicate to the patient. A physician advising a patient to seek service of another physician is acceptable. However, in case of emergency, a physician must treat the patient. No physician shall abruptly refuse treatment to a patient. However, for good reason, when a patient is suffering from an ailment which is not within a range of experience of the treating physician, the physician may refuse treatment and refer the patient to the another physician. Patience and delicacy should characterize the physician. Confidence concerning individual or domestic life entrusted by patient to a physician and defect in the disposition or character of patient observed during medical attendance should never be revealed unless their revelation is required by the laws of the state. Sometimes, however, a physician must determine whether his duty to society requires him to employ knowledge obtained through confidence as a physician to protect a healthy person against a communicable disease to which he is about to be exposed. In such instance, the physician should act as he would wish another to act toward one of his own family in like circumstances. A physician should neither exaggerate nor minimize the gravity of patient's condition. He should ensure him that the patient, his relative, or his responsible friends have such knowledge of the patient's condition as will serve the best interest of the patient and the family. A physician is free to choose whom he will serve. He should, however, respond to any request for his assistant in the emergency. Once having undertaken a case, a physician should not neglect a patient, nor should he withdraw him in the case without giving adequate notice to the patient and his family. Provisionally or fully registered medical practitioner shall not willfully commit an act of negligence that may deprive his patient or patients from necessary medical care. When a physician who has been engaged to attend an obstetrics case in absence and another is sent for a delivery accomplished, a acting physician is entitled to his professional fees, but should secure the patient's consent to resign on the arrival of the physician engaged. In consultation, however, in the case of serious illness and in doubtful or difficult condition, a physician should request consultation, but under any circumstances, such consultation should be justifiable and in the interest of patient only and not for any other consideration. Consulting pathologist, radiologist, or asking for any other diagnostic lab investigation should be done judicially and not in the routine manner. In every consultation, the benefits to the patient is of foremost importance. All physicians engaged in the case should be frank with the patient in his attendant. All statement to the patient or his representative should take place in the presence of the consulting physician except as otherwise agreed. The disclosure of the opinion to the patient or his relatives or friends shall rest with the medical attendant. No decision should restrain the attending physician from making such subsequent variation in the treatment if any unexpected changes occur. But at the next consultation, reasons for the variation should be discussed and explained. The same privilege with its obligation belongs to the consultant when sent for an emergency during the absence of attending physician. The attending physician may prescribe medicine at any time for the patient, whereas the consultant may prescribe only in the case of emergency or as an expert when called for. When a patient is referred to a specialist by attending physician, in case summary of the patient should be given to the specialist, who should communicate his opinion in written to the attending physician. A physician shall clearly display his fees and other charges on the board of his chamber and or the hospital he is visiting. Prescription should also make clear if the physician himself dispense any medicine. It's about the next is responsibilities about physicians to each other. The physician should consider it as a pleasure and privilege to render gratuitous service to all physicians and their immediate family dependents. In consultation, no insincerity, rivalry should be indulged in. All due respect should be observed towards the physician in charge in the case, and no statement or remark be made which would impair the confidence reposed in him. For his purpose, no discussion should be carried on it in the presence of the patient or her representative. Whenever a physician requests another physician to attend his patient during his temporary absence from his practice, professional courtesy requires the acceptance of such appointment only when he has the capacity to discharge the additional responsibility along with his or her duties. The physician acting under such an appointment should give the most consideration to the interest and reputation of the absent physician, and all such patients should be restored in the care of the latter upon his return. Duties of physician to the public and to the paramedical profession. Physician, as good citizen possessed of special training, should disseminate advice to the public health issues. They should play their part in enforcing the law of the community and in sustaining the institution that advance in interest of humanity. They should particularly cooperate with the authorities in the administration of public health laws and regulation. Physicians, especially those engaged in public health work, should align the public concern, quarantine regulation, and measure of the preventing of epidemic and communicable diseases. At all times, the physician should notify the constitute public health authorities of every case of communicable diseases under his care. In accordance with the law, rules, and regulation of the health authorities, when an epidemic occurs, a physician should not abandon his duty for fear of contracting the disease himself. Physicians should not recognize and promote the practice of different paramedical services such as pharmacy and nursing as profession and should seek their cooperation wherever required. Some unethical acts. Soliciting the of patient directly or indirectly by the physician, by a group of physicians, or by institute or organization is unethical. A physician shall not make use of him or her as subject of any form of or manner for advertising or publicity through any mode, either alone or in conjunction with other, which is of such a character as to invite attention to him or to his professional position, skills, qualification, achievement, attainments, specialty, appointments, association, of such character as would ordinarily result in his self aggrandizement. A physician shall not give to any person, whether for compensation or otherwise, any approval, recommendation, endorsement, certification, report, or statement with respect of any drug, medicine, surgical or therapeutic article, apparatus, or appliance, or any commercial product, article with respect of any property, quality, or use thereof, any test, demonstration, trial of for use in connection with his name, signature, or photograph in any form or manner of advertising through any mode, nor shall he boast a case, operations, cures, or remedies, or permit the publication of report thereof through any mode. A medical practitioner is, however, permitted to make a formal announcement in press regarding the following: on starting practice, on changes in a type of practice, on changing address, on temporary absence from duty, on succeeding to another practice, public declaration of charges, printing of self photograph or any such material of publicity in the letterhead or on signboard of the consulting room or any such clinical establishment shall be regarded as act of self advertisement and unethical conduct on the part of the physician. A physician may patent surgical instrument, applicants, and medicine or copyright applications, methods, and procedures. However, it shall be unethical if the benefits of such patent or copyrights are not made available in situation where the interest of large population is involved. A physician should not run any open shop for sale of medicine, for dispensing prescriptions prescribed by doctors other than himself, or for sale of medical or surgical appliances. It is not unethical for a physician to prescribe or supply drugs, remedy, or appliance as long as there is no exploitation of the patient. Drug prescribed by a physician or brought from the market for a patient should explicitly state the proprietary formulate as well as generic name of drug. A physician shall not give or receive, nor shall he offer to give or receive any gift, commission, bonus in consideration of or written for the referring, recommending, or procuring of any patient of medical, surgical, or other treatment. A physician shall not directly or indirectly participate in or be the party of act of division, transference, assignment, subordination, rebating, splitting, or refunding of any fee for medical, surgical, or other treatment. The prescribing or dispensing by the physician of secret remedial agents of which he does not know the composition or the manufacture or promotion of their use in unethical and as such prohibited. The physician shall not abet torture, nor shall he be a party to either infliction of mental or physical trauma or
Can you all hear me?
Yes, madam, you are
Hello,
audible,
yes,
but madam,
yes.
Praful madam is not audible.
Okay, Praful ma'am is not audible. Anyway, meanwhile, I invite our special guest who is presiding this event today, who delivered his lecture yesterday, which was a very well planned discourse on the penalties act in competition law. And it was delivered by Dr. Rajkumar Sandhu from Department of Law, University of Jammu, located in Jammu and Kashmir. He is today presiding the event because somewhere we felt that yesterday, due to some technical snag or glitch, we delayed our half an hour session. And even regretfully, I would say that one speaker had been so angry to miss the his deliverance, that even I'm requesting today again and again to him to turn up and to deliver and take the space. He was chartered accountant, Dr. Girish Gupta. So perhaps he would not be here again today. Anyway, we are so much obliged by Dr. Rajkumar that he has agreed to come back to us to preside the event and to follow up what our co host yesterday spoke, and to even to create a platform so that our co-host may not feel that he's the only person who is left at the end and speaking alone, and none of the participants are sharing his thoughts or they are participating in his talk. So it's a a pattern that when a teacher or a professor is speaking, the student or the pupil or attendees or the delegates need to be very actively involved. So I request all attendees, all speakers, whosoever have been invited or enthusiastically attending it, please participate when your speakers deliver something to you. So here, I think Praful, has she joined or not? Can anybody see? So if she's not
No, madam.
here,
Yes, she is not here.
Kripa, are you here? Kripa, Miss Kripa Jain. I think Praful has come back. She has come back.
She
She
has
has joined.
joined now.
Yes, sir.
I'm
Let
sorry.
Yes, ma'am, I'm here.
yes, Praful, continue with your discourse.
Very sorry for description.
Don't mind. Everything is in a smooth flow. We filter the gaps, or we do the fillers in the gaps, or you give fillers in the gaps.
Yeah, thank you so much, ma'am. So I was discussing about the signing professional certificates, reports, and other documents. Registered medical practitioners are in certain case bounded by the law to give or may from time to time be called upon or requested to give certificate, notification, reports, and other documents of similar character signed by them in their professional capacity for subsequent in use in the courts or for administrative purpose. Example, such documents among other includes the one given at yes. Yeah. And the other is the registered medical practitioner shall not contravene the provisionals of the Drugs and Cosmetic Acts and regulation made there under accordingly prescribing steroids, psychotropic drugs when there is no absolute medical indication, selling schedules H and L drugs and poisons to the public except to his patient, performing or enabling unqualified person to perform an abortion or any illegal operation from which there is no medical, surgical, or psychological indication. The registered medical practitioner shall not issue certificate of efficiency in the modern medicine to unqualified or non-medical person. A registered medical practitioner shall not refuse on religious ground alone to give assistance in our conduct of sterility, birth control, circumcision, and medical termination of pregnancy when there is a medical indication, unless the medical practitioner feels himself or herself incompetent to do so. Before performing an operation, the physician should obtain in writing the consent from the husband or wife, parent or guardian in the case of minor or patient himself, as the case may be. In an operation which may result in sterility, the consent of both husband and wife is needed. He shall not publish photographs or case report of his patients without their permission in any medical or other journal in a manner by which their identity could be made out. If the identity is not to be disclosed, the consent is not needed. In the case of running of the nursing home by a physician and employing assistant to help him or her, the ultimate responsibility rests on the physician. Punishment and disciplinary action. It must be clearly understood that the instance of offences and the professional misconduct which are given above to do constitute and other not intended to complete list of the infamous act which calls for sorry 1 minute I'll back.
Okay. Actually, she's in hospital and she's also attending to some urgent call there. That's why she switched off her camera. Kripa, are you there? Miss Kripa,
Yes, ma'am, I'm here.
can you turn on your camera?
Yes, ma'am.
Would you like to introduce yourself and would you like to tell us about your institute, both BNU and MLSU? How are your experiences? Can you share something before we start with your presentation and fill the gap?
Sure, ma'am. Good evening, everyone. I'm Kripa Jain, and I've been an alumni of BN College. I've completed my LLB from the college itself, and currently I'm pursuing LLM from the prestigious college MLSU. Um, About me, I think ma'am has already introduced a lot, so I'd not take a lot of the time and rather I'd request if I could shift to the presentation.
I just don't know. Should we cut short Madam Praful? Because then, if she will come back, how would she feel?
Yes.
So that's why I said that you just talked about your experiences, how the activities Faculty of Law BNU conducts. What are those kind of activities? How the students from BA, LLB or LLB they work in different kinds of activity. Can you just bring out some kind of light to all those things which you have gone through while being a student in Institute of BNU?
Ma'am, one of the most important and basic aspect of our work is advocacy and the advocacy skills. Like we need to be very vocal about what we feel and where we stand and what we do. So therefore, studying is one aspect of what law is, but then at the same point in time, it's very important that where we come from, what we speak, what our opinion stands, and therefore, one of the most important aspect of our studies is moot court activities. So I'd like to say something about moot court. So moot court is basically it's a platform. It's an artificial courtroom practice. That's a very important subject that we have in our final years. But then apart from that, there are several competitions that are held like nationally and internationally. So I am blessed that I've got an opportunity to be a part of national level moot court twice. Um, one was held in Udaipur itself, and another was in Jaipur. So the Jaipur moot court competition, we were lucky that we have won prizes there, and we have stood at the third position at the national level. There were 40 teams which are competing for that competition. So basically, moot court is where we get a problem. It's a practical issue. We get a practical case where we go through, and there we come up with the arguments, we stand, we speak, and that's what it goes through. So this is one of the most important aspect that our college provides us. Apart from, there was an internship which we did, which was from Rajasthan District Legal Services Authority. There also we got to go through a lot of different like practical things that go through the courts. So, yeah.
And there's one last question to you, because students are very much very participatory in all sorts of learning activities. One more question to you, Kripa, that somewhere you mentioned that you had got one paper published. Okay, ma'am has come back. Yeah, ma'am, please continue.
I'm very sorry. That was an important call. So I was on the topic punishment and disciplinary action. It is made clear that any complaint with regard to professional misconduct can be brought before the appropriate medical council of disciplinary action. Upon receipt of any complaint of professional misconduct, the appropriate medical council would hold an inquiry and give opportunity to the registered medical practitioner to be heard in the person. If the medical practitioner is found to be guilty of committing professional misconduct, the appropriate medical council may award such punishment as deemed necessary or may direct the removal altogether or for a specified period from the register of the name of the delinquent registered practitioner. Deletion from the register shall be widely publicized in local press as well as in the publication of different medical associations. In case the punishment of removal from the register is for a limited period, the appropriate council may also direct that the name so removed shall be restored in the register after the expiry of the period for which the name was ordered to be removed. Decision on complaint against physician shall be taken within a time limit of 6 months. During the pendency of the complaint, the appropriate council may restrain the physician from performing the procedure or practice which is under. This is all about from my side.
Yes. Um, Thank you, Dr. Praful Bala, Honta. Uh, you have really given an exhaustive study on what kind of regulations one need to follow as a practitioner, and what kind of an organization is medical college, where not only the medical professionals work, but they are also some kind of stakeholders, giving to society, to students, as well as to their own families. So in a way, medical practitioner is in a way a large, creating a spectrum of responsibility, ethics, regulations, and even a kind of knowledge of legislation is very much necessary for this category of stakeholders. I'm so gratefully and with deep heart, full of gratitude, from the host university, Bhopal Nobles University, and from the co-host, that is Guy's Institutes, the International Institute for Advanced Legal Sciences, Buenos Aires, and the co-host is Professor Salvatore Tolone Azzariti. He would be really grateful that you have taken out your precious time, because we can see you are somewhere in your hospital in your uniform, and just switching to some kind of the passionate target that is imparting knowledge to audience. I requested many of the doctors, and it is you who has taken the lead, and we are really happy. Salute to you. Salute.
Thank you.
So if you have time, keep your means connected for a while, as the co-host will come around or before 8 o'clock. You come back, so we can all have a good photograph on screen with him. Okay.
Okay. Thank you
I
so much.
invite, yeah, I invite next speaker, Kripa. Please come on board.
Yes, ma'am. Thank you, ma'am. So, I'll be talking about the contractual liability, and so I'll start hereby. A contract is an agreement enforceable by law which offers personal rights and imposes personal obligations, which the law protects and enforces against the parties to the agreement. The general law of contract is based on the conception which the parties have by an agreement created legal rights and obligations which are purely personal in their nature and are only enforceable by action against the party in default. Section 2 of the Indian Contract Act defines a contract as an agreement enforceable by law. The word agreement has been defined as every promise and every set of promises forming consideration for each other. A contract to which the central government or a state government is a party is called a government contract. So, government contracts have been accorded constitutional recognition. The Constitution, under Article 298, clearly lays down that the executive power of the Union and of each state extends to the carrying on of any trade or business and to the acquisition, holding, and disposal of property and the making of contracts for any purpose. The Constitution, therefore, provides that the government may sue or be sued by its own name. Hence, the subject of the government contracts has assumed great importance in the modern times. In the modern era of a welfare state, government's economic activities are expanding and the government is increasingly assuming role of this dispenser of a large number of benefits. Today, a large number of individuals and business organizations enjoy largesse in the form of government contracts, licenses, quotas, mineral rights, jobs, etc. This raises the possibility of exercise of power by a government to dispense largesse in an arbitrary manner. Therefore, there is a necessity to develop some norms to regulate and protect individual interest in such wealth and thus structure and discipline the government discretion to confer such benefits. The concept of enforcement of legal rights against the state in terms of a contract could be traced way back in 1785, long before the commencement of the Constitution of India. The contractual liabilities were conferred upon the East India Company in regard to its commercial transactions. The prominent significance of contractual liability was that the doctrine of sovereign immunity had no effect upon such liability, and therefore the company could be sued in its own courts just as a private individual. In England, the concept "the king can do no wrong" had its way. All the courts in England were under the crown and hence owed not to be sued. Absolute immunity was provided to the crown and hence couldn't be held liable for the acts of their servants. After the Crown Proceeding Act 1947, the immunity provided to them was abolished and the crown could be held liable for contractual or tortious obligations. Therefore, the doctrine of liability of the East India Company was expounded by the court in Moodley versus Monton, which drew a distinction between the sovereign function and non-sovereign functions of the company in terms of contractual transactions. The court observed there is a great and clear distinction between the acts done in the exercise of what are usually sovereign powers and acts done in the conduct of undertakings which might be carried on by private individuals without having such powers delegated to. The court further observed that when the company enters into a contract, it does so in a civil capacity, just like any other private individual, and subsequently, on breach of its contractual liability, could be enforced towards the other party to the contract. Thus, it could be rightly said that the concept of contractual liability had great historical significance long before our democratic republic came into existence through the Constitution. Its traces could be seen or found in several statutes like Government of India Act 1833, 1858, 1915, and 1935. Hence, the Article 300 of the Indian Constitution states that the Government of India may sue or be sued by the name of the Union of India, and likewise, the state government may sue or be sued in the name of the state or the legislature of the state. Thus, the Constitution expressly confers the legal personality upon the state and recognizes it as a juristic person capable of holding and acquiring property, making contracts, carrying on trade or business, bringing and defending legal action, just as a private individual. In Calcutta Corporation versus Director of Rationing, the Calcutta High Court also reiterated the same and held that the legal personality of the Union of India or a state of Indian Union is thus placed beyond doubt by the express language of Article 300. Article 299 authorizes the Government of India and the state government to enter into contract for any purpose subject to the mode and manner provided by Article 299. It says, all contracts made in the exercise of the executive power of the Union or of a state shall be expressed to be made by the President or by the Governor of the state as the case may be. All such contracts and all assurances of property made in the exercise of that power shall be executed on behalf of the President or of the Governor. Its execution must be by such person and in such manner as the President or the Governor may direct or authorize. Therefore, there are basic three requirements for a valid governmental contract. First, the contract must be expressly formed. It is an essential condition for a valid government contract under Article 299 that it must be in a proper form, that is, it must be written. Where a contract is not expressly made or is orally made, such contract is not sufficient unless there is some external manifestation of such intent by way of a written contract. In Vikraj Jaipuria versus Union of India, the Honorable Apex Court also reiterated the same and held that where a contract is not properly formed, it is unenforceable. However, the interpretation that the contract must be formed as provided by Article 299 sometimes becomes inequitable to the party dealing with the government, difficult therefore to mitigate such situations. It has been held that the execution of the contract does not always mean the contract to be in written form of a legal document. Reliance could be taken from the case of Union of India versus A.L. Ralia Ram, wherein the court held that the mere fact that the officer failed to express that he is executing the contract on behalf of the president can be ignored if the facts given if the facts give an inference that it has been made on behalf of the president. In Chaturbhuj Vittaldas versus Moreshwar Parasharan, the Supreme Court observed that sometimes it would be practically impossible to adhere to the particular form of instituting a contract by a government officer, as they have to enter a variety of contracts, some in emergency and even some of petty nature, and therefore the scope of an oral contract cannot be put out of the doors, and where circumstances demand such contract could be formulated. Second, the expression must be in the name of the president or the governor, as the case may be. Another significant requisite for a valid government contract is that it must be expressed in the name of the president or the governor. Where a government contract is not expressed in the name of the president or the governor, as the case may be, even though it may be made by the authorized person, such contract would not be enforceable. In Devakor's Garments Factory versus State of Rajasthan, an agreement was entered into between a contractor and the government. The contract was for the supply of police uniforms, but it was signed by the Inspector General of Police in his official status without mentioning that the agreement was executed on the behalf of the governor. The Supreme Court held that the contract was invalid and void. It is a noticeable point that under Article 299, the president or the governor shall not be personally liable in respect of any contract or assurance made or executed for the purposes of this Constitution or for the purposes of any enactment relating to the government of India. Third, executed by an authorized person. It is also an essential requirement for a valid government contract must be by an authorized person. It means that the contract must be executed by such person as the president of the governor may direct or authorize. Such direction or authorization may be by way of rules, notifications, special orders, etc. Thus, where a contract is executed by an unauthorized person, it shall not be binding on by the government. In Bikaji Jaipuria versus Union of India, the railway administration accepting the offer of the firm purchased the food grains from the firm and made the payment. The purchase order has been issued by the divisional superintendent, who had not been conferred any special authority, but from the facts of the case, an inference was drawn by the court for grant of special authority to him to enter into the contract. Here comes the repercussions of non-compliance of the Article 299. First is ratification. The provisions of Article 299 are mandatory. Thus, it is pertinent to understand that neither the government nor the person entering into a contract with the government, not in the prescribed form provided by Article 299, is enforceable and is liable for the breach thereof. Hence, there can be no implied contract between the contracting parties, or else the provisions of Article 299 would be nothing more than a dead letter. The Honorable Apex Court in the cases of Mulanchand versus State of MP and Jitram Shiv Kumar versus State of Haryana also expressed the same view and held that a contract not in compliance with Article 299 would be no contract at all. But does that mean that such a contract cannot be reviewed back or ratified? The answer to this could be traced by analyzing different precedents. The state of West Bengal versus B.K. Mondal, the court held that the contract entered into with the government not conforming with the provisions of Article 299 was not void in the technical sense, and thus it could not be ratified by government. In state of Bihar versus Karan Chand Thapar Brothers Limited, the court held that a contract entered into by an unauthorized person could be ratified by the government, but in Mulam Chand versus State of MP, the Supreme Court held that a contract not conforming with the provisions of Article 299 could not be ratified, as the enactment of Article 299 was not a mere formality and its provisions could not be dispensed with. The same view was also adopted in Fernandez versus State of Karnataka, wherein the court held that the provisions of Article 299 are mandatory and must be complied with. If the requirement does not comply, there shall be no binding contract. Second is restitution. When there is a contract not in compliance with Article 299, the contract is not enforceable, but the doctrine of restitution applies to such contract. Under Section 70 of the Indian Contract Act 1872, if a person lawfully does anything for another person or delivers anything for another person or delivers anything to him and his intention is not to do so graciously, and such other person enjoys the benefit of that act or thing, then that person who enjoys the benefit is bound to make the compensation to the doer of the act or to restore to him the thing so delivered. Instead of West Bengal versus B.K. Mondal, the court accepted the position of government as that of a citizen, and subsequently the government was made liable not under a contract but under a relation resembling those created by the contract under Section 70 of the Indian Contract Act 1872. In Pannalal versus Deputy Commissioner, the court held that where the government had made the payment but the contract was void, it was recoverable under Section 65 of the Indian Contract Act 1872. Another important point of consideration is that where under a void contract the person has performed his part but the government has not benefited from it, whether it would be liable to compensate. The clouds in this regard were cleared by the Honorable Apex Court in the state of UP versus Murari Lal, wherein the court held that the provisions of Section 70 will not be attracted where the government has obtained no benefit from the acts of other party. To conclude, the examining of all the essential provisions in case laws clearly infer, firstly, in order to confer the contractual liability upon the government, the provisions of Article 299 shall be satisfied. Where a contract is created in non-compliance to the said provisions, such contract would be void and it can also not be ratified by the government. Secondly, the government would be liable to compensate or the doctrine of restitution will apply in the case of benefits obtained from the performance of other party under Section 70 of the ICA and not otherwise. Thus, it could be rightly said that the provisions of the government contract as such, which protects the interest of both the stakeholders, that is the general public and the government. Thank you, ma'am.
Yes, thank you, Kripa, for joining us at a very short call, acknowledging our invitation and delivering such a nice discourse on contractual law and liability. May I invite Dr. Ashutosh, Dr. Rajkumar to please appreciate our young scholar, alumni, Kripa Jain. Please, all of you turn on your cameras.
Good evening, ma'am, and all participants. Uh, Good evening from my side. So, regarding this lecture, I would like to say that it's very well presented. All aspects relating to this liability in contract were discussed. What are the basically meaning of the contract was discussed, and legal definition which is given in the contract act. It was also discussed by the presenter. Then various case laws were discussed in which different aspects of liability were provided. Then there was a discussion on government contracts and what are the legislative and constitutional provision dealing with the government contract, especially Article 299, where certain requirements are prescribed for government contract which need to be followed. And if these requirements are not fulfilled, in various judgments, Supreme Court had decided that the government will not be liable. So overall, it was very well presented, very well structured, and it provided us with the comprehensive knowledge relating to liability in case of contract, and what are the various rulings, and how courts have interpreted this provisions. So overall, I would like to thank the presenters for providing beautiful insight into this aspect. And that's all from my side. And I thoroughly enjoyed the presentation, and it was very enriching for me also. Thank you.
Thank you so much, sir. Thank you.
Rajshri ma'am, over to you. Ma'am, your mic is mute. Rajshri ma'am, you are still mute.
Yeah.
Over.
So we are all here ready to listen to our Professor Salvatore sir. We have been very much consciously waiting that when will you arrive and bless us with your short lecture. Of course, it's in your terms, it's a discussion, but for us, it's a lecture. May I introduce you, sir? Professor Salvatore is an expert in civil law, human rights, and basically his expertise is absolutely in the study of tort, and he has been serving, maybe you may say a veteran now, but he had been very much a good professor in the University of Oxford, then in Universidad de Palmero, hope I'm correct, pronouncing correctly, and then currently he's located at Argentina, and he's been there in the Universidad de Buenos Aires, and his mission is to collaborate his knowledge with certain institutes. Especially, he has extended his integrated spirit with our institute, you may say a host institution, Bhupal Nobles University. And for 4 months, he has been contributing through certain lectures on special days, celebrating our international days also. Coincidentally, our dean, Dr. Ashutosh Pitiliya, he became enthusiastic. He thought that why not to extend further relationship. So he proposed me an idea that should we go for some kind of seminar. I said my professor mentor Salvatore is also in the same spirit. So we finally came into some kind of, decision making, and then we organized a symposium, and this is the third day of symposium, and Professor Salvatore has been there for half an hour with us every day with the theme, the changing concept of liability and its variables, and he is also the co-host of this symposium. So all the invitations to all the speakers has been undersigned by him. Of course, I am as a representative extending all invitations through email, but it is with his permission and with his guidance that I have been doing all this work. And Ashutosh Pitiliya is here to, bridge the two persons, because I belong to the Department of English and of course teach there as an adjunct faculty in the law department, legal English studies. So I am thankful that all of you have given such kind of integrated platform, either from international borders or from local borders and from national borders, because Dr. Rajkumar Sandhu, who is from University of Jammu, he delivered his lecture yesterday, and so finally he planned his lecture on competition law. that I think it is very urgently required in the current scenario of changing paradigm shift in the markets. So I now leave my voice here and invite Professor Salvatore to continue with his discourse of today.
Wrong button. Thanks so much, dear Professor. Once again, just to correct it, that to amend your presentation. Thank you very much. That honored me actually. But I'm still in Oxford, unfortunately. I say unfortunately because my mother country. Okay, sorry. My mother country won last summer the European Championship, Italy against England in Wimbledon. So it became very hard for me. But I'm since long time in Oxford, and I'm still there as my main base. I'm also in Argentinian academics in the University of Buenos Aires, or as they said in Spanish, Universidad de Buenos Aires. And yes, I chiefly care about law of property, law of torts, and law of contracts. Also law of contractual liability and whatever, fundamental rights. Yeah, I'm not so young, and so I had long experience in this fields. And of course, I will be very, very happy to have a further and larger cooperation with your honorable university that honored me many times, and trying to have to submit something in return with our institute that we are constituting. It is an international institute, so it is beside to be virtually based in Argentina because of my presence here, but it will be an international institute aiming and to realize that, one of the most important projects that legal scientists can to which a legal scientist can aim today, that is the circulation of the rules, the circulation of a legal experience, even between countries that seem to be far away, but in the end they adopt many common principles, many common rules, and so it is something that is useful to support this kind of approach to the current legal problem in private law. But beside these, of course, there are something that is naturally international in itself. Of course, law of torts is one of these. Law of torts is normally constituted by a different approach, mutually interchanged by many countries and many experiences without any barriers concerning the political boundaries or geographical boundaries, because it is one of the elements, it is one of the area in private law that can really join many experiences, many different experiences. So we hope that in this area, many of the rules, of the suggestions, of the institutional suggestions may circulate, favoring the mutual advancement of the experiences. And if I can start with having I repeat, it's having so great and very prestigious audience. I cannot define it as a lecture. It's only a talk concerning my point of view upon some problems, nothing more than this. We yesterday I introduced the concept of one of the main concepts that concern the law of tort today, that is, the spatial elaboration to which, in absence of any norm, of an every definition, in absence of many, I yesterday recorded the European experiences, and I found only a very short and unsuccessful, I believe, definition concerning the nexus of causality in Austria. Austria has this kind of definition, But beside this exception, we have not, any conceptualization, a concrete definition of a conceptualization of this important element in all the kind of liability law that we study today. It is not matter of law tort. I remind to myself that, for example, when we discuss the concept of remoteness in the liability in law of in contractual damage, so as a consequence of the contractual unenforcement and the breach of contract of many other kind of hypotheses, we have always made the problem of fixing a limit, a barrier to the extension of the damages that can be recovered by demonstrating that are consequences of a breach of a contract or consequences of anyway an enforcement of the obligation deriving from contract. So we have always this problem that coexists with this area of a study since its beginning. We can say from the history, I remember in private law, in Roman private law, that they faced the same problem, and we are talking about thousands of years. So this is one of the areas upon which I wish to insist, in order that we can understand how can we contribute as jurists to suggest many solutions to the legislator that is dealing with this kind of problem, and of course approaching to this problem to many areas where the law towards us is effect. Let's say we are discussing upon the most important area, like environmental damages, liability for damage to natural resources. And so this is a collective good that has been many times in many countries under attack by many possibility of harmful conduct. That this kind of question will be the question of the future, not only of the past. We are following new technologies that are at the same time protective, but at the same time maybe very harmful. So I believe this is one area that we must focus chiefly, especially at this level, like the present here, the attendant, the people attending here, the dear colleagues attending to my talk. This is one of the most important areas upon which we must focus our study and our suggestions through our works. Hopefully published in this is what we are working on with Dr. Singh and with your honorable university. I wish to focus today upon a national, true national experience, one more extensively, and the other one as a matter of suggestion for what we are not able today of prevent by the activity of law of tort. More precisely, I yesterday introduced the concept of incommensurability among many goods. In what sense? That if we find that the double function of a preemption and of a recovery of the damages in law of torts, because we normally exclude the deterrence factor that is typical to the, let's say, to the punitive damages in the United States, we must say that many times either recovery or the possibility of a, let's say, light deterrence is not working when we face irreplaceable goods like the health, nature, the health of the people, nature, or the physical integrity, life, and something like this. This kind of approach is much more modern today than it was yesterday. We must say that everybody, at the process in which, thanks God, we put at the center of the legal universe, and I would say the general universe, the extreme value, the incommensurable value of a human being. So this is what we do, putting it in the medium, and this has a reflex in every field of legal studies that concern concern the private institutions in society. The paradigmatic system that I wish to adopt today is the German one. The German liability system adopted in 1990 the Environmental Liability Act, that is the Gesetz über die Umweltverhaftung. Here again, like we discussed yesterday, the premises for overcoming the previous regulatory system were dictated by an environmental tragedy that occurred in neighboring Switzerland, namely the environmental disaster involving the Rhine River and following a fire at a chemical plant in a small city called Schweizer Halle. I remember that I was studying in Germany only 2 years after this, and more or less of night of this legislation, or the first effect of this legislation. I must say that, and I was in a city that is beside the Rhine River, and I must say that it was very, very, very sad to say the effects even after 2 years of this event. Let's think that the consequences of depollution spread across the Rhine River as far as Rotterdam in Netherlands, very far. The sense of this legislation that took place after this disaster, so the Environmental Liability Act, lies in its concreteness and the strict consequentiality of its provisions. We will say that the more we are simple, the best we open the possibility of application of legislation. So, being very strict in this description of this system, we may say that the legal goods concerned are the property, life, and health in its more general form. And the means by which damage can occur are the ecological means of air, water, and soil. The protective measures are of different kinds. So we have the criminal protection for many, much more grievous criminal conduct, civil protection, and administrative protection. The causative factors of environmental damage, which are relevant for law enforcement purpose, are many. We can say that everything that causes damage, material, vibration, noise, pressure, rays, gases, steam, heat, or other phenomena which are emitted into soil, air, or water. The kind colleagues that are listening can understand that when we put a general clause in the hand of the norm, like these other phenomena which are emitted into soil, air, or water, we can open our interpretation and apply it to every kind of activity that can be relevant under this norm. So, after this very good intentional structure, we must face what I told you yesterday as an example of what I told you, that is the problem of the causation factors. That means the problem of individuation in the concrete case, the nexus of causality. What are the solutions that have been adopted by German legislation? There are two normative techniques. I repeated yesterday that around the nexus of causality we have the normative techniques through which nexus of causality may be subsumed legally, independently, or with a very easy connection with the factual causality. Well, the legal causality is here has took place through an attempt to overcome the problem of verifying the causal link through the normative technique of presumptions and reversions of the burden of proof. That means that the element of causation, the nexus of causality, is presumed as verified at the moment in which, prima facie, a particular facility of the defendant is inherently suited to cause the damage. Okay, so in the moment in which we have a damage and the presumed cause, because of the kind of activity they are carrying on. Just a second, I have two children that are very noisy today, but I cannot sue them for recovery the damages. The element of causation is presumed as verified at the moment in which, so we have the defendant is because of particular facility, let's say an engineering, let's say a factory, because of production, because of whatever, you know, that the very large area of application may be as a consequence in the very large application to the facility that can be suited for causing the effect. And so these in this case, so it is inherently suited to cause the damage. That means that if I live in the center of a town of a city in which there are many disco clubs that are let's talk about, you know, noise as a form of intervention and as a form of factor causing damages. There are many disco club. You know that this is a problem to understand in the moment in which the damage is caused. That is not an instant damage, but is a permanent one. Okay, we should detect what is the concretely the disco club that is causing it. At the same time, we must. This is one of the factors that give us the possibility of intervention, horizontal intervention through all the possible factors causing the damage, reversing the burden of proof. At the same time, when there are a lot of factories that are emitting with their emission in the air, and a subject that is reasonably close to this facilities, suffering from something that let's say belongs to his breed. Well, in these cases, we have the possibility to have an inherent switch to all these factories in order to reverse the burden of proof. So this is the claimant's evidentiary burden by shifting to the defendant the task of showing an absence of causation. What does it mean? The presumption is this is the technical presumption, and was as a consequence the reversion of the burden of proof. I mean that many, in our example, the disco club must demonstrate that they never overcome the level of noise that can be harmful to a subject who's the claimant, living, let's say, at 500 meters from the disco. Who is not able to demonstrate this? On the contrary, who cannot demonstrate this because he has overcome this limit? Well, this is surely one of the liable subject because of this facility who are emitting a noise. The other example is the same. If we detect that the subject that the claimant has suffers from something belonging to his breed, and we have a concrete pathology and a concrete definition by a medic, we must reverse the burden of proof, and all the facility that can be involved for their emission in the air must come to defend themselves by demonstrating that, or they're not able to reach the distance, the normal distance of life between the subject who's damaged and they. or that their emission has nothing to do clinically, medically, with the kind of a pathology that has been detected in the climate. Okay, so this is the technique that we know as a thousands of years. That is the inversion or reversion of the burden of proof given the presumption. If there is something happening, I presume that is caused by the facility that stay there. If it is the facility because of their activity that must demonstrate they are not liable for anything. The legislation, German legislation, add an element to this. That is the so-called the normative concept is the properly operation, in the sense that the proper operation, in the sense that the facility is working following all the special operational duties. What does it mean? The question of presumptive causation is prevented to arise in the case that the defendant demonstrates that his facility was properly operating. That means that facility fulfilled all special operational duties and no disruption of operations occurred. If I have a high decibel production of sound, in the case of a disco bar, but I operated working on the walls of the disco club that prevent the sound to go outside. This is a form through which the owner of the facility can demonstrate that this presumption has not ground to arise. At the same time, if I have the depurators of air depurators inside my facility that produce inside of the facility of the factory the potential harmful air pollution, but they have depurating them before this pollution go out, ultra lowering the levels of emission, it can be easier for the facility owner to demonstrate that the presumption has not justification to arise, because it is only in the clear or in the near area that can be, many subjects can be subjected to this kind of harmful inhalation. But the subject, let's say the workers or the employee, but this subject are by other side properly protected by masks or something like this. So this facility has nothing to do with the pathology that has been detected inside the climate that who's living, let's say, 500 meters far from the facility. So the concept of a proper operation, having met the special operational duties, is something that can go on discharge of the defendant in the case of indicated by the German legislation. So that means that special operational duties means, as a concept, means the compliance with all the regulatory duties aimed at the prevention of the form of pollution we are discussing. So every kind of pollution may have a special administrative directive that having many special different form of liabilities, let's say criminal, in the case if you are not complying with these directives, and if they are met, the presumption will not arise. Another legal instrument for defendant is the so-called umstand, that is the concurrence of another circumstances. It is what I told you in the example of the noise as a sound, as a sound pollution. If there are many disco club in the same area, and we found that, a distance, we have a calculation, physical calculation from the subject that is treating the disco club. So because it's for his lamentation of a damage, we can the owner of the facility of the disco club that is involved may demonstrate there is the concurrence of another circumstances that in this case will be of the same type. Okay, let's say that there are many disco club, and so there is many other that are not respecting the same rules as they do. So the proportion between the decibel of the sound and the protective investment of the wall is not the same for all this kind of facilities, and so we can individuate. We as defendant, we can individuate the colleague, let's say, that is not properly carrying out his activity. So this is the so-called umstand. We can have a umstand that can be of dishomogeneous. In what sense? That we can demonstrate that the kind of pathology that has been harmful for a subject may derive from two different concurring elements of a pollution or of a sound pollution in the case of noise. One is a disco club, but another one is a facility that producing something, and it is in the same area, or having more harmful impact because of the of being carried out in open air, not on inside a closed facility. So we can demonstrate this. This is a discharging proof that is another element that can prevent the arising of the prevention of the presupposition, and so there is not in these cases the reverse of the burden of proof, because we are intervening at the beginning as a causal factor. I'm not the cause of this pathology, of this damage. The cause of the damage is another subject that can be homogeneous or dishomogeneous or whatever. Of course, beside this, once we entered in the game, let's say, of the burden of proof to be reversed and demonstrated, there are procedural ways through which the defendant can rebut the reversion of the burden of proof, but it doesn't preclude the normal way of proceeding, of course, by which onus probandi, burden of proof, belongs to the claimant, who then can demonstrate the liability by demonstrating the nexus of causality. So what that means that, of course, even once the defendant has successfully rebutted the reversion of burden of proof, demonstrating, let's say, that there are many other disco club, or there are many other sources of noise, or there are, let's say in the other example, many other sources of pollution, air pollution. This does not entail automatically that we have the final proof, because the final proof, beside everything in nexus of causality, is always a concrete proof. Concrete proof, that means that the specific pathology must be connected to a specific cause. So if we have the generical proof in the case of noise, let's say, that can be harmed, that can be harmful to the climate, even without a difference between the source or the nature of noise, the high volume music, or the facility activity of a factory, of whatever it is. In the case of, let's say, of air pollution, the concreteness that we must prove in order to find the nexus of causality as determinant of the proof, what is? It is the causal link, of course, as we very well know, between the kind of pollution and the kind of pathology. Two forms of different pollution, even in terms of autonomous relevance for a general interest are not of the same type in the case of the pathology we are discussing now. Of course, we know that we must individuate the cause and the exactly cause. So once the defendant has been able to prevent the arising of the or to reboot the burden of proof, this does not prevent him from liability until the claimant has been able to demonstrate, on the contrary, that this nexus is concretely the same. Okay, so this is the third level of concreteness after the procedural way through which the German legislation provide the protection in these cases. Furthermore, to confirm that the question of causation is the most important issue in this field, residing at the heart of the liability system, especially environmental liability, but in general, for the protection of all those goods that we define as commensurable and irreproducible. A constant examination of German cause law is worthwhile. For example, the distance between facility and injured party, when the non-technical, let's say medical rules, do not allow a causal link to be established, or a precise causal link to be established. This is a very important sub-area in the context of a nexus of liability. We work always, when we go to the technical data and we go to the technical proof, we work upon what we know. We do not work upon what we don't know. It is elemental, is something tautological, but what does it entails? What does it entail? It entails that we can not being always able to dominate all the rules that are occurring and are necessary in the fixation of a nexus of the concrete nexus of causality. We still don't know what is the different resilience of the single ears, of the single sensibility to noise of the different subject that can be harmed by a different facility. So even if we have a standard of distance, of a standard of protection, of a prevention, of the harmful pollution of noise, we do not know until what point we can differentiate single subjects one from another. And this may be relevant in the case of establishing the concrete nexus of causality. The same is about many of these experiences of many experiences for which many of the causing elements have not been detected in time, at the times in which many harms have been produced and damages have been produced, that the level advancement, the advancement of natural sense, the natural senses involved in these cases has not been so far able to give a proper rise to liability, but first of all to the causal connection between the activity, the pollution activity, and the harmful result upon the subject. We have this many times in medicine, we have many times this in engineering. Asbestos was one of the most harmful examples that affected my country, Italy, for a long time. Another one, so it is this derived that another concept that must be fixed in the examination nexus of causality is what German legislation synthesizes as properly operated. Because when we say that an activity inside the facility is properly operated, we are putting an equation between the kind of activity that is carried out here inside according to the standard of technical and scientific knowledge that we can have in describing it, in its potential harmful effect upon the community. upon this kind of knowledge and upon this kind of advancement of science and whatever the sciences involved in defining this kind of activity, upon this ground we justify we justify or not the operation of this facility. We can say that there is prevented some form of external pollution until we know what is the ground through which we commensurate the protection. In the case in which we are not still able to anticipate this, or we are not able to define properly the kind of activity or the kind of goods or that are protected, that are produced inside this facility, we are not able at the same time to establish a standard of prevention. And this is consequential also. And this is one of the problems through which, nexus of causality work upon many elements. The advancement of science in engineering or in medical or in many other branches as a consequence inside our criterion, because we can import. This is to go back to the to the transnational relevance of the law of torts. When we have a spatial detection of a special article going published in United States concerning some kind of harmful effect of food, of goods, or technical or production, we can employ this also wherever in the world, because we know that the homogeneous production carrying out in India or in Italy or in Europe has the same characters of the one that has been detected as harmful in the United States. So this is a basic element, constitutive element of nexus of causality that enters directly in our equation of judgment. I wish to close by the last thought upon such topic, hoping I will not annoy you too much today. But how it is important to focus the possible development of this topic. This is I believe that we should focus on internal prevention. Internal prevention that is an element that is present, for example, in Italian Civil Code under Article 2050. I repeat the letter of the norm. Whoever causes damage to others in the performance of a dangerous activity by its nature or by nature of the means used is obliged to pay compensation if he does not prove that he has taken all appropriate measures to avoid the damage. We have to separate, I will do this very quickly, separate two elements. By one side is the dangerous activity. It is something that belongs to our society. We live and we have a many benefit from the many dangerous activity. But at the same time, the one who perform this kind of activity has a special duty to prevent by appropriate measures to avoid the damage. This is not. This is a norm that coexists with the Civil Code from 1942. So it's a very nice norm, but I believe it is a very, very appropriate today, because it is not concentrated upon the activity, but is concentrated upon the effect of activity. It is like a mirror's game. If I look at what I'm doing, I can say many times that I'm properly and adequately preventing. But if I look outside and I see the potential damages, I think that is different perspective through which I must be much more careful. And I, as a legislator, incorporated the duty of prevention and no more concentrating on the duty of prevention upon the activity. What I mean, I can say that in 99% the pollution that has been emitted by a factory can be not maybe not be harmful to anybody, because except the 1% of people who suffer of a determined pathology, and who has to live in 300 meters from the factory. Okay, so I believe that the proper prevention, that according to the German example, maybe has been met in these cases. On the contrary, if I'm liable for all the consequences independently by what I have properly or improperly do, it is different. Because I must admit that the 1% of people can live at 300 meters from my factory, and I must prevent this potential liability. Okay, so it is different, but I believe that it seems to be the same things, but it's not. It is not, because in the prevention of damage does not depend by always by the proper course of activity. Many times the proper course of activity is very difficult to be determined. We assume a routinary activity, and we assume that the standards are met in the cases in which we consider that this routinary activity has to be the core of the factory. But factory may meet a lot of exceptional circumstances, different each other, and these cases are not prevented in the cases in which we apply only the standard of operational compliance. We must at the same time put the activity of the prevention to the damage, not to the activity. It is a very important element of the modern study and proposal, if you want, in matter of a nexus of causality, because it separates the two areas inside all the dangerous activity. The area of exercise that must be careful and compliant with all the directives, and the area of prevention not being accomplished by the conformity to the directives, but the area of prevention, this is studying what happens outside. This, in short, well implies that the factory has to carry on research, and that the standard, governmental standard may suggest this. Governmental standard may suggest that every kind of fabric having such characteristic and having such property, potential pollution of this kind, this type in the area, must adopt some kind of advancement in the science of prevention, to be generical, and in a mandatory form. So the government may help in this way, because dangerous activity is always authorized by government, but the government at the same time authorizes technically what it has to be done. I hope that this is an embryonic form, an embryonic area through which we will have a fruitful cooperation through the institute or through your faculty, wherever you want. Thanks so much, dear colleagues. You are very kind today, especially for having being so patient with me. Thank you.
Thank you, respected Professor Salvatore sir. I would like my expert, Dr. Rajkumar, to please join in and to throw light with your insight.
Good evening, everyone. Good evening, Professor Saltoro. It was a really nice presentation, and although you were saying it's not a lecture, it is just a talk, but for us it is more than a lecture. It is ocean of knowledge and your experience which you have earned in Europe and working in different parts of the world. And we are highly obliged by your lecture, by your insights about the topic, and the way you presented it with a lot of examples. So we are absolutely delighted with your talk on this topic. And for me, I'm definitely looking for further to write about it, and to explore the different aspects of this liability, and how we can relate it with the concept of liability which is there in the torts and other laws. And I must say that it is really a very good lecture, thought provoking lecture, and it's a power pack lecture, I must say. And again, thanks for your lecture, thanks for enlightening us, thanks for giving your valuable time to us, and enlightening us about your lecture. So thank you. I would like to thanks to Jayshree ma'am for this event, and bringing experts from different part of India and out of India for our interaction. And I'm looking forward to associate myself with your university in future, as well as and when, if you're organizing an event, or if you want our participation, you can invite me as well, or I'll be happy to join as an audience. So thank you from my side, and now over to Jayshree ma'am.
Yeah, with gratitude, I extend my heartfelt thanks. And, it's real good pleasure and privilege to see you all uniting yourself with certain mission and vision. Indeed, liability is into a different, kind of forms and elements as described by Professor Salvatore. So naturally, we are heading towards very good experts from tomorrow onwards. A lot of professors have collaborated with me. We are lucky that Professor Salvatore has requested me to get some journals and reviews, accessibility, and with support of Dr. Rajkumar, he has extended to me a lot of addresses of journal and reviews. I will be posting to Professor tonight whatever he has given to me. So you can subscribe, or you can add yourself into those as per your expectations. I would also like to invite yesterday's one of the other very bright speaker and the research scholar, Bhumika Chaubisa. Please join in.
Thank you, ma'am. Thank you so much. I'm invited for vote of thanks. So I would like to come on my concern. An adorable evening to everyone, to our most valued honorable chair, speakers, guests, and management committee, of course, and dear colleagues and every gathered here. It's my privilege to propose a vote of thanks and acknowledge the contribution of those who worked really hard to make this symposium happen successful. And today we had an opportunity to hear your thoughts, and this will surely be going to encourage us in our future. And my gratitude to all the speakers for gracing this symposium and sharing their opinion. And today was really a graceful evening we had, and a much special thanks to Honorable Professor Salvatore. With regards, sir, and thank you so much once again to one and all. Thank you.
So a big hug for you from all of us. So anybody else? Dean, Dr. Ashutosh ji, are you here? Dr. Ashutosh? Has he left?
Professor, I see many questions in the chat.
I think Dr. Rajkumar is there to moderate the questions. to the
Yes.
panelist and the co-host. Dr. Rajkumar, please take the
Ma'am,
platform.
question is raised by you, so it is better that
No, but
you
you
ask.
have to you have to make them short. Do the
Okay.
Good evening, doctor. How are you, Ashutosh?
So the question is regarding the rehabilitation of liable subjects and objects in case of punitive damages, and what is the presumption of truth and the causality of concurrence of circumstances. So again here I'll give it to Professor Salvatore for his comments on this question.
Thanks, dear doctor. It's always a pleasure to hear from you. I hope you are fine and to meet you soon, even if virtually until now. And thanks for the question concerning punitive damages, because this allow us to put the the focus upon. I will do it shortly because I suppose I annoyed you too much today. But we have the opportunity to put the difference between the course of law of torts and the course of punitive damages. That is, according to my opinion, I wrote an essay upon this item. It is very difficult to apply even in the case of English common law. That was the mother of punitive damages that now are applied only according to these features only in United States, but they arose in English common law. And I very humbly, I envoy to my essay in order to have this kind of differences. Why punitive damages are so special? Punitive, even in the case of rehabilitation of liable subjects and objects in this case. Punitive damages are a mix of criminal deterrence and liability law. Even if the cause and the area of application is a law of torts, because in case of crimes, they are another kind of this follow another kind of a process that is a criminal process, and the two may concur in some cases. Well, the punitive damages have this kind of spatial legal ether. Let's say the first thing is that law tort does not entail any form of enrichment for the damaged subject. Let's we remember that all what liable subject pay in case of law tort is a compensation for damage. It is not an enrichment. On the other side, punitive damages is made, the quantification of the payment is made upon the patrimony of the harming subject. So the liable subject is calculated upon his patrimony, and upon his patrimony is irrigated the payment to the damaged subject. This is why we heard this kind of excessive numbers in matter of punitive damages, because they are not compensating what is the actual damage suffered by the damaged subject. They are trying through this number to harm the judge. The system is harming the patrimony of the subject who behaved in some way producing this kind of damage. To go out from the equation through which that is a stable equation of lasting thousands of years, through which that says that through law tort we cannot enrich the harmed subject. We have only to compensate his damage. To go out these punitive damages, to go to have a spatial area in this area of the legal system. Punitive damages is applied only with a different subjective psychological element that must be found in the behavior of the harming subject, of the defendant. Wantonness, regardless, this is not the willful conduct. This is much more than willful conduct. It's willful and insensible to the consequences. This is, let's say, the cases, famous cases for Philip Morris. This is many other cases for subject for very good and very important higher range factories or corporations that have been hit by punitive damages. They do not only cause the damage. Let's say that the time is an element that intervene to modify the subjective psychological element in the requalification of a normal course of law tort to a special course of punitive damage. When I find that the factory, the corporation, or the subject is behaving for a long time in the same way, even not facing, this is why this can be useful to our or my idea upon this, even if the first effect of the harmful activity can be detected, they go on producing at the same way, not intervening on the prevention in this sense, not in their proper production or proper activity, but in the sense of the prevention of the effect. Okay. Well, in this case, we have a requalification of the subjective element, of psychological element. Okay? And in these cases, the rehabilitation of liable subjects or the objects, of course, it starts from the past, because it is normal. We've detected some behavior, some psychological approach to a behavior. We detected some harmful activity, and we work upon this for many years. When we arrive at the sentence and the condemnation, we have to refound a different alternative way of behaving and a different alternative, way of approaching to this element. We have not, because punitive damages stop themselves as deterrents. Okay, whoever has studied the penalty clauses in English common law, we know that penalty clauses is called penalty, so they cannot be applied to in an enforcement of a breach of a contract in the case it is in terrorem, when it is provided a very high, too much high amount in the case for breach of one party. Well, the concept of in terrorem, to terrorize the subject, is exactly what is received as legal and purposeful in the concept of in the punitive damages. This is way, for example, that many times they are substituted by the so-called doublet or triplet damages, because it has altered the competition in many areas of the market when a company is being subjected to the condemnation to punitive damages. Okay, so with the triple damages, they say that the compensation is the level through which we can mensurate 3 times the value of the resource that the defendant must pay to the claimant. Okay, so the compensation will at least reach the triple of the concrete damages that have been individuated. But we must say that in case of punitive damages, we cannot consider even as a minimal impact the compensation value of the damage. What we consider is the behavior, and in the moment of defining the amount, we must say how much this multinational, how much this company, how much this corporation has as a patrimony. Here is the commeasurement. Thank you very much.
Yes, sir.
Thanks for your valuable insight, and thanks Jayshree ma'am for raising the question, and thanks sir for explaining it in a comprehensive manner with examples. Any other participant, if they have any question, they can raise.
Kripa, are you there? Kripa? Kripa Jain?
Yes, ma'am.
Do you have anything to say, remark on behalf of your dean? He is not there. He is to chair the session and he has left. So you just do something to compensate the punitive damages.
Firstly, I'm really, really privileged, and I feel this opportunity is very, very big for me. I've got an opportunity to hear Professor Salvatore. It's such a great privilege. So I'm really grateful.
Okay, sir.
Thank
Thank
you.
you.
Thank you, doctor. It's a pleasure for me. It's a very privilege for me to have the attendance of so much very high ranked and very, very attentive colleagues. Thanks so much.
Yes, sir. So tomorrow at 6:30, we would be continuing with the same for today. And I think tomorrow also we have got very good speakers. Now because other universities has collaborated. Of course, Rajasthan University cooperation had been extended through Dr. Rajkumar. He was referred to us from Rajasthan University, Jaipur. But his friend, Dr. Manoj Meena, is still skipping, or you may say escaping us. So, Dr. Rajkumar, tomorrow you have to bring him in.
Ma'am, he is traveling today and he'll be there tomorrow.
Because he was actually referred to us by Professor Jaya Chakravarti, formerly head and dean of arts, University of Rajasthan, Jaipur. So it is because of her reference that we have been in continually, pursuing others. So we would like him to be, please, here with us.
Yes, ma'am, sure. I'll talk to him and he'll be there, definitely.
Yes, sir. Dr. Praful. Dr. Praful, are you here? Yeah, please, sir. She actually delivered. She's a medical practitioner and professional, and she is currently most probably in the hospital. And she delivered today the lecture. Of course, you will listen to it in replay recording. But please, Praful, could you just do a favor by speaking something to us?
Thank you so much, ma'am. Hello and namaste to Salvatore sir and everybody. And it was a very great experience because this is not our routine to join this such kind of symposium because of patient load, and we are doing daily emergency duties and clinical works. But today I got opportunity to join this symposium, and it was my lucky day because today I'm meeting you all. And thank you so much to giving me this opportunity and discussing about this topic which is very relevant to me also. Thank you so much.
Thank you.
Namaste.
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 Anybody else? Jayendra Sisodia. Are you a student? Or Jayendra Sisodia? We can see you on screen. Please
Yes,
turn
ma'am.
on your camera, unmute yourself, show your face. The last goodbye from you to all of us. Come on the screen. I think he's a student. He's just shying from us. Anyway, sir. Okay, sir. Thank you for being here. And tomorrow we'll continue. Goodbye to all of you.
Thank you.
Everyone.
Thank you. Thank you. Thank you, everybody. Thank you. Thank you to all
Thank
of you.
you. Thank you, ma'am.
Bye bye.